Hey guys, welcome back to the channel. Lieutenant General Khumalo of the Crime Intelligence Unit is back in court together with his co-accused. They want their bail conditions to be reviewed. They want to go back to work, and one of the conditions of their bail was that they are not supposed to be near the premises of their employer. Surprise, surprise, Advocate Teffo is also there to oppose their bail conditions not to be reviewed. Advocate Teffo tells the court that he was arrested and harassed by accused number one, and as a result, accused number one, who is Lieutenant General Khumalo, is a very dangerous man. So those bail conditions should remain as they are for his own safety. He said he's appearing in court as a friend of the court, not as an advocate. Accused number one's defense lawyer, Advocate Mshololo, opposed Advocate Teffo's application. She says her clients are prejudiced, and there is no such a thing as friend of the court in criminal law. Friend of the court is in civil matters, not in criminal law. That is according to the defense advocate Mushololo. So Advocate Teffo will file an application in writing, and then the state and the defense will argue on the matter, and the magistrate will come up with a ruling. Let's listen to their argument on this matter. Do not forget to subscribe, like, and share. Drop your comments, please, guys. Let me know what you think.
As well, Lordship, that in the gallery, and I'm going to request Mr. Teffo to come closer. There's also Advocate Teffo, who just approached me, Lordship, that he also wants to make an application to be a friend of the court, Lordship. I don't know at what stage the court will accommodate that, whether we should start with Mr. Teffo's application as an amicus curiae before we get into the other applications. May Mr. Teffo introduce himself into the record.
he wants to apply as a friend of this court. And above that, the application will be opposed. In criminal law, we never have had such an advocate who wants to join the proceeding as a friend of the court. In civil court, yes, we do know the proceeding. It does happen like that. And my clients will be prejudiced should this court allow my learned friend, Mr. Teffo, to continue placing on record the allegations that he wants to place on record. And it's prejudicial, it should not be allowed. He cannot be allowed even to get a platform to address his lordship regarding such application. That is not proper before this court. Those are my submissions.
May it please the Honourable Court. Your Worship, I'm also of the respectful submission that learned friend Mr. Teffo should file his application with the clerk of the court and serve copies of his application to us as the state and to the defense so that we can have insight into what the application is all about, and we can then respond and set out whether what our view is regarding this application. I'm afraid that already he was going into the merits of what his issues are about without us having insight into his papers. It's not that we've already made a decision on whether we're going to oppose or not, but if the court can make an order, we already have a date on which the case has been postponed to. Mr. Teffo can be given time frames on when to file his papers, and then the other parties can then respond.
I give a response there, yes. I'm appearing here not as a counsel, as an applicant who is a normal citizen in this country.